opinion in the appeal of Villiers against Villiers.
Yes, Mr.
My ladies, my lords, I appear with Mr. Lang for the appellant, Mr. Charles Villiers in this case, and then for Mr. Scott QC with Ms. Campbell QC and Ms. Southey appear for the respondent, Mrs. Emma Villiers, and my friends, Sir James Eady QC with Mr. Magpile and Mr. Podjay to my left, the intervener Secretary of State. My lords, the issues in this appeal relate to the jurisdiction of a court in England and Wales to entertain an application under Section 27 of the Matrimonial Causes Act for a maintenance order, and whether that court is able to decline jurisdiction in favour of the courts of another part of the United Kingdom, in particular, in this case, Scotland. Ladies and my lords, there are 4 issues. The first being whether, by virtue of the construction of Section 27(2), the court in England and Wales has any jurisdiction at all in a purely internal domestic case with no international element. Second issue is whether, if there is jurisdiction, the courts may decline to exercise it on the basis that the courts of another part of the United Kingdom are a more appropriate forum. In other words, whether the power to stay proceedings relating to maintenance on the grounds of forum non-convenience is available in relation to another jurisdiction within the United Kingdom. The third is if the appellant is wrong about that and that that power is no longer available, whether or not the removal by the 2011 regulations was ultra vires, Section 2.2 of the European Communities Act 1972, and in particular, as we'll develop the point, whether it was ultra vires Section 2.2b of the 1972 Act. And the fourth and final issue is whether, in the alternative to the forum non-convenience grounds, whether the court had discretion under the domestic version of Article 13 of the regulations to stay these proceedings on the basis that the Scottish divorce writ was a related action for the purpose of Article 13.
Yes, I think you can take it for granted that the court will be more interested in issues 2, 3 and 4 than in issue 1.
I'm very grateful for that. I don't propose to say anything more about the facts. Our written case says a bit more about it than perhaps might be usual, but only because we are at an interim stage. And further facts or further evidence has come to light since the interim findings. But I accept, and of course my majority of my oral submissions will focus on issues 2, 3 and 4, and I won't say any more about, say, the factual matters. Issue 1. That submission is, as set out at paragraph 27 of our written case at MS 2111, that construing Section 27(2) of the 1973 Act, there must be jurisdiction under both the International Maintenance Regulation and Schedule 6 to the 2011 regulations. Our key submissions are that the maintenance regulation only works, only is effective in cross-border cases. That secondly, unlike the other legislation which was amended by the 2011 regulations, the Section 27(2) is phrased rather differently. It is not positive conditional, it is no jurisdiction unless. And finally, the third main submission in relation to this is that in this context, and means and. And to borrow some adjectives from my learned friend's written case, it is both conjunctive and copulative. In terms of the main submission there, I have to make good is whether or not the maintenance regulation has no application to a purely internal matter, My submission there is one looks at what the maintenance regulation was made under, and that is the relevant EU legislation. We'll look also at the case of Owusu and Cook and Virgin Media, and then I'll conclude by referring to the passage from Briggs. The question therefore boils down to, does the maintenance regulation apply directly as the law conferring jurisdiction in any case, whether cross-border or not? And we say the answer to that is no. The written case at paragraph 30 refers to the legislative competence of the European Union at the time, and the reference there to Articles 61C and 65. For the court's reference, they are at MS 517 and 519. I would like to take the court to the decision of the Court of Justice, or the European Court, in Owusu and Jackson. That is Authorities tab 56 at 1604. And I should also point out that in the course of preparing for today, my junior reminded me that the report of the Advocate General is not in the official series of the law reports. It is a very thorough report running to some 281 paragraphs, but I have made available to the court some extracts from it. And I'll say why in a moment. Of course, the court will be very familiar with this case. Mr. Owusu sued Mr. Jackson and several other Jamaican companies in relation to an accident suffered by Mr. Owusu in Jamaica. Both the claimant, Mr. Owusu, and Mr. Jackson, the first defendant, were domiciled in England and Wales. So far as those two parties were concerned, it was a domestic case. If I can turn the court, please, to paragraph 23 at MS 1609. Court will see there that the main proceedings, I suggest, are defined to relate to the proceedings between the two domestically domiciled parties. And one will see into the next page, at 24, of course, the issue in this case being, did the regulation or did the convention apply between a contracting state and a non-contracting state? The suggestion in 24 is there need not be, but in 25 it was clear from the Gennard report that there must be some international element to be required. And of course, on the facts of that case, there being an accident that took place outside the United Kingdom, at paragraph 35 on 1611, the conclusion was that Article 2 did apply in those circumstances. My ladies, my lords, I made extracts available from the Advocate General's report to the court available because there are some suggestions in that the view of the view expressed in the Gennard report was not one that was universally shared, and for the court's reference, that is at paragraph 103. And the Advocate General is summarising an argument put forward by other parties making submissions in that case and authors. So, ladies and my lord, I accept that this submission is one which perhaps goes against conventional orthodox assumptions about the ambit of the scope of both the Brussels Convention and the various regulations. But I say that there needs to be an international element. If I can finish off on this point in relation to the quote from Professor Adrian Briggs. We've cited a passage from that at our paragraph 31 at MS 2113. Right to say that it's a section from Professor Briggs' book, which starts a long way before that, and the extract is in the authorities bundle at MS 1784 under the heading International Scope. The particular passage, in addition to the one we've cited already, I'd ask the court to look at is at MS 1786, and the paragraph at the bottom there beginning the Brussels I regulation.
So looking at the bit that you've quoted in 31, the reference to the regulation on the fourth line is to the judgments regulation.
My Lord, yes.
Yes?
And that's the context, my Lord, to which the passage citing it, because the passage on 1786, beginning the Brussels I regulation, follows on from the passage we've cited. You'll see at the bottom of that page, in that paragraph, there is still a requirement for an international element, albeit that it must be satisfied in what the author says in a way that might be described as arbitrary. And of course, I do emphasise the word any in the end of the first sentence that we have cited. It is not one in which the regulation is designed to have any role. One final point in relation to that is that it is undoubtedly true that the Brussels I regulation does leave a number of matters open for national law, and it is also true that recital 15 to the maintenance regulation would appear to, at first glance, exclude relevance to national law. So the maintenance regulation is at tab 5, MS 102, and recital 15 is at MS 103. And the penultimate sentence concludes there should be no longer any referral to national law. My ladies, my lords, my submission in relation to that is simply that assertion is in the context of a party that's, or a dispute, as it were, between a member state or a contracting state and a non-member state. And that's the context in which that assertion is made. I should also point out, as we do in our written case, that there is the decision of the Court of Appeal in Cook and Virgin Media, which we have cited at paragraph 30, subparagraph C of our written case, which also says that the international regulations do not apply to purely internal jurisdiction, the fixing of purely internal jurisdiction.
Mr. Horton, your argument is based on section 27.2.
My Lord, yes.
Would you be prepared to go to section 2 of volume 1, page 10, so that we can just look at that subsection?
Yes.
You are relying upon subsection 2 in italics,
My Lord,
are you
yes.
not?
That is.
Can you just help us as to the other subsection 2 in square brackets underlined?
Lord, yes. So if one turns on to page 12, you'll see the amendment section, and the first subsection 2 is substituted by the 2011 regulations. So that is, the words in italics are the ones which were inserted by
Of course.
2011 regulations. The further subsection 2 would have effect, my understanding is, in the event of a no-deal exit from the Union. And so they are amended or put in by the Jurisdiction and Judgments Family Amendment and EU Exit Regulations 2019. That's the full title, I think, of SI 2019/519, which, my Lord, you can see at the bottom of page 12.
So as we speak, subsection 2 is in italics.
My Lord, yes. I also, sorry.
Mr. Horton, looking at it again, subsection 2 in italics, may not entertain an application under this section unless it has jurisdiction to do so, by virtue of the regulation on Schedule 6. Doesn't it mean by virtue of the regulation on Schedule 6 where these apply?
My Lord, I would say no, because the author of the regulations made a positive choice to frame that provision in that way. When one looks at the other provisions in section 35, that my learned friends refer to in his written case, in the section of the Matrimonial and Family Proceedings Act, they say where the regulations apply, jurisdiction will be governed by those regulations.
Well, I'd noticed that. So all the analogous or potentially analogous changes do say where the regulation and Schedule 6 apply, then such and such. You rely on the fact that this particular one is differently worded. Is that right, Mr. Horton?
I do, my Lord, yes. And, my Lord, at page 2153 in the respondent's written case, one can see the different, the three other examples where it's done the other way.
Well, quite.
And, my Lord, I say that the choice may have been done because Section 27 was originally framed in negative terms. The court shall not entertain jurisdiction unless. But I say there is a difference there. It would have been perfectly open to the maker of the regulations to have done it in the positive conditional way that they did elsewhere. So, my Lord, that's my submission on that point.
Okay.
My Lords, my Lady, that's all I'd wish to say in relation to the first issue. I say that it is perhaps a conclusion that might one raise an eyebrow at. It does not, in my submission, lead to absurd results. It does not leave parties without a remedy.
How many applications under Section 27 are there every year?
My Lady, I suspect very few. I think I've seen one reported case on Bailey in the last, apart from this case, in the last 5 years. And I mean, the typical example, my Lady, of course, is someone who the marriage breaks down within the first year of marriage. But of course, there's always the availability of issuing a judicial separation petition in those circumstances as well.
Well, there could also be people who have conscientious objections to those sorts of proceedings. So,
Indeed, my Lady.
but my impression has always been that it's very rare. But
Indeed, I think the authors of Raden Jackson say it's very rarely used. And I wouldn't go so far as to say it's a dead letter. It's clearly got some life in it, but it is, as I say, very rarely used. My ladies, my lords, I'll move on to issue 2, if I may. That's in relation to whether or not the court retains a power in internal forum disputes internal to the UK in maintenance cases, whether the power to stay on forum non-convening grounds is retained. What I intend to do here, ladies and lords, is to say a few things in general about forum non-convenience, to deal with the role, if any, of the maintenance regulation itself on allocating jurisdiction within member states, then to turn on to our arguments about the construction of the 2011 regulations, and then to see whether or not the test for, as it were, determining whether the power to stay on forum non-convenience grounds has been implicitly removed, what that test is and whether it's been met. I'll deal with, very briefly, the relevance of section 16 of the Matrimonial and Family Proceedings Act, and then deal with our secondary structural argument. In terms of forum non-convenience, to start with, if I can, excuse me, deal with some general comments at paragraph 36 in our written case at 2115, and indeed from paragraphs 34 onwards, a number of adjectives spring out: civilised, deep-rooted, deeply embedded, brilliant, and indeed later on we refer to it as ancient. It is, of course, an invention of Scots law that has eventually been adopted in the rest of the United Kingdom. Of course, it continues to apply in forum disputes internal to the United Kingdom, in matters relating to divorce, in matters relating to child arrangements, in matters dealing with the civil proceedings which are governed by the judgments regulation. And of course, it undoubtedly applied to internal forum disputes relating to maintenance issues until June 2011. The other preliminary points I want to make in relation to this is that Section 49, subsection 1 of the 1982 Act, which we can find at MS 43, is on its face not a provision which confers the power, it is a saving provision. We need to go elsewhere, outside the 1982 Act, to find it. And of course, it's a common law power, and that's relevant, of course, to our argument about whether it's been impliedly removed. Forum disputes can seem disproportionate. Lord Justice Thorpe in More and More said that there had been disproportionate sums spent on what he termed was a sterile dispute. The dispute in this case is far from sterile. It does matter, given the different laws that apply in different parts of the United Kingdom, as to which court has jurisdiction. In More and More, the evidence was the Spanish court would apply English law in any event, even if it had jurisdiction. But forum non-convenience is not the sole cause of disproportionality in relation to forum disputes. And of course, and then remind the court that More and More, at first instance, took 4 days before Mr. Justice McFarland, and there were 2 experts on the meaning of various terms and the nature of the Spanish proceedings. So getting rid of forum non-convenience, as it were, does not mean that forum disputes have evaporated or become easier to manage. On the contrary. My ladies and my lords, I'll do next with the role of the European legislation as far as it concerns allocation of jurisdiction within the member states, because it's our case that this is purely a matter of domestic law, purely a matter of the construction of the 2011 regulations. And I deal with it now because it relates both to this issue and also the Villiers issue, but in the written case of the intervener, at paragraph 25 onwards, MS 2193, there are arguments put forward in favour of the idea that the maintenance regulation itself has removed forum non-convenience, at least in unrelated actions. So I want to make a number of submissions in relation to that. The first and the most clear-cut and obvious is the wording of Articles 12 and 13 of the Maintenance Regulation themselves, and that's Authorities tab 5, excuse me, MS 109. The obvious point is that the application of both Articles 12 and 13 of the Maintenance Regulation is they apply where there are proceedings in the courts of different member states. But I also have some additional submissions to make in relation to that. The first is that in general, the European legal order is unconcerned with how member states allocate jurisdiction internally within themselves. And in relation to that, I rely on some observations of the Advocate General in the Kleinwort-Benson case. That is Authority tab 25 at MS 697.
If you could give us the bundled number as well, that might make things even quicker. But if you can't, we understand.
That
it's
is
2.
2. Sorry.
Where do you want to take us to in Kleinwort-Benson?
The particular matters are at page 69G of the report, MS 709. Paragraph 9, the Convention was not concerned with internal conflicts as to territorial jurisdiction. And later on at page 75, D to E, MS 715, the last paragraph, last sentence of that paragraph, the scheme of the Convention as a whole is indifferent to purely internal situations. And of course, the particular matter that was at issue, and as a result of that, the European Court declined to make any answer to the questions that had been referred, because the matter, or the interpretation of Schedule 4 to the 1982 Act was therefore a matter of domestic law. But it's also worth pointing out that the provisions in question, what was then Article 5.1, dealt with jurisdiction in matters relating to a contract in the courts for the place of performance. So we have the word place in both the maintenance regulation here, in Articles 3A and B, but also in that particular context. So the mere fact that the provision conferring jurisdiction refers to a place rather than a court of a particular member state can't, in my submission, say that the European legal order is concerned with internal allocation. Two things more to say about that. Of course, the 68 Convention was a treaty. Judgments regulation and the other regulations are regulations which have direct effect. Does that make a difference? I say no. The 1968 Convention had, the source of law was Section 2 of the 82 Act. It was therefore became part of our law, and of course the regulations come into our law by virtue of Section 2.2 of the 1972 Act. So there's no difference there in relation to direct effect or otherwise. The other matters to say in relation to that are the maintenance regulation is no different as to the Brussels Convention or the Judgments regulation so far as internal allocation, unlike Brussels II revised, which does refer to, as it were, federal structures and says that they should be treated specifically in relation to that. There's no equivalent of Article 66 of Brussels II revised. Ladies, my lords, I've had Article 66 made available to the court. That provides, for instance, that reference to habitual residence in a member state shall refer to habitual residence in a territorial unit where there's more than one systems of law that apply. In addition, of course, if it were the case that an international regulation had removed the power to stay internally on forum non-convenience grounds, then the decision in Cook and Virgin Media would be wrong, and no one suggests that that is the case. So, in my submission, the answer to this question is found in the 2011 regulations, not in the maintenance regulation. And finally, on this point, it will be relevant to Alvari's point as well. The fact that internal allocation of jurisdiction is a matter for member states means that the drafters of the 1982 Act had policy choices available to them. They could have made their own rules up from scratch as to how to deal with primary rules of jurisdiction and how they could be resolved. Of course, in the end, they decided to copy but modify the scheme of the 1968 Convention. They could have done that, but also included a provision specific to maintenance. It's often said that both the Brussels Convention and the Judgment Regulation and the Maintenance Regulation is designed to offer the maintenance creditor a choice of jurisdiction. For reasons which I'll say in a moment or two, that is not such a clear-cut choice. There are circumstances in which a maintenance creditor won't have that choice. But if that was considered to be an overarching consideration, we could have said, in matters relating to maintenance, where there are two or more courts with jurisdiction in the United Kingdom, it will always be the choice of the maintenance creditor which one he or she is allowed to adopt. And of course, that would have been a perfectly legitimate policy decision made by Parliament when it enacted the 1982 Act. And I'll come back to that in relation to the Vari's points. Other options, just for the sake of completeness, we have the Australasian example of cross-vesting, so where there is one court with jurisdiction, other courts, federal, local, or Commonwealth, have jurisdiction as well. Those are all entirely legitimate choices that the authors of the 1982 Act could have come up with. And that's the case regardless of the content of both the 1968 Convention and now the Maintenance Regulation. So, to sum up there, my submission is the Maintenance Regulation itself does not deal with internal allocation of jurisdiction, and that, as I say, just follows from the wording of Articles 12 and 13 needing there to be proceedings in more than one member state. If I can turn next, ladies, my lords, to the arguments about the construction of the 2011 regulations. Of course, the Court of Appeal held that by making the 2011 regulations, the authors had implicitly removed the power to stay maintenance proceedings on the grounds of forum non-convenience in relation to internal UK disputes. Of course, for the reasons we set in our written case, we say that that creates anomalous situations, and we say that, therefore, the court should not assume too readily that that was indeed the intention of the makers of the regulation. It was, in effect, a silent abrogation of an existing common law power, and an existing common law power that was key to the earlier scheme. In terms of what we've classed the external aids, our written case deals with those particular external aids I want to deal with, forgive me, are those set out at paragraph 25 at 2109. And for the court's reference, the full version of these is at MS 1721, but I'm hoping not to have to take the court to them. We start off with the very first sentence of the purpose of the purpose of the regulations, forgive me, and that is to make provision to remove legislation inconsistent with the Council regulation. And of course, I pause there to say that there's nothing inconsistent with the maintenance regulation in having forum non-conveniens as the method of resolving internal jurisdiction disputes. It's true to say in paragraph 2.2 that the statutory instrument says, it's halfway down, it makes provision for allocation of jurisdiction in maintenance matters between the different parts of the United Kingdom. And we've also quoted on MS 2109 there at subparagraph C, paragraph 7.3 of the explanatory memorandum, and the changes which are embodied in Schedule 6. Now, the choice that is...
Can I just ask you a question about 7.3?
Yes.
It's on your page 2109, it's the last line, more or less, and then overleaf. This follows the approach taken when the Brussels I regulation was applied in 2002, so that the law for domestic maintenance cases between the UK jurisdictions was aligned with the requirements of the EU legislation. Now, they're saying that the 1982 Act was aligned with the judgments regulation. But the 1982 Act had, in section 49, a saving for forum non-conveniens. So when you say at the bottom of page 2110, hard to fathom, are you talking about that bit? I think you probably are.
My Lord, yes. What the CJJO, the order made in 2001, which was made on the coming into force of the judgments regulation, what that order did was to effectively update and indeed replace a completely new Schedule 4 to the 1982 Act. Of course, Schedule 4 to the 1982 Act was never a direct copy of the Convention, and the new Schedule 4 is not a direct copy of the judgments regulation. But for instance, there were new provisions relating to employment in the judgments regulations in Articles 18 and 21 that weren't in the old Schedule 4 that became part of the new Schedule 4. And so what the makers of that regulation did was to say, we have some new primary rules of jurisdiction at the EU level, and we can go down each of them and decide which one we're going to say, yes, we'll adopt that makes sense in applying it in a domestic context. But no, where we've already departed from the regulation, we're going to continue to do so. So there was, as it were, updating of primary rules of jurisdiction, and that's what I understand. Of course, it's a matter for Your Lordship what you understand by that, by the meaning of that, following the approach adopted in the 2001 order. But
I mean, mine is a more focused inquiry. Can one possibly say that the amendments made in 2002 to the 1982 Act aligned with the judgments regulation when the 1982 Act retained a power to stay for forum non-conveniens?
Of course, my Lord, the entire structure, when one had the 1968 Convention, the 82 Act from its outset retained forum non-convenience. And of course, when the 2001 judgments regulation comes in, what the order does is simply, as I say, update some of the primary rules of jurisdiction, and of course forum non-convenience is left in there, both by, as it were, section 49.1 saving it. Of course, the other matter is there's nothing equivalent to lis alibi pendens provisions or the related action provisions in any version of Schedule 4 that's appeared. But the point is, if they were going to follow the approach taken in 2001, that would be, I say, amending the primary rules of jurisdiction.
Isn't it a more straightforward point than that? That can't be right. Paragraph 7.3, the part that my Lord has quoted to you, simply can't be right. Can't be accurate, because they didn't align.
Well, I say it's hard to fathom, my lady.
Well, I thought that might be helpful to your argument.
Indeed.
I thought it might be too.
Indeed, my Lord. And forgive me, I'm not trying to be ungrateful. If the intention was, the subjective intention was as expressed in that paragraph, I say, then the, as it were, the making or the inclusion of any provisions which would appear to contradict that may have been an error. Going back, if I may, just very briefly to, and the reason why I say, to drop my lady's point, my lord's point, if one goes back to the choices that 7.3 in the explanatory memorandum set out at 2110, the choices that are offered seem to be, don't amend the 82 Act at all in relation to maintenance, leave it there referring to the old EU law, or doing what they did. And, of course, there's no reference at all to saying, well, we can retain forum non-convenience as a method of resolving internal forum disputes, or supplement it, or restrict it, or get rid of it completely.
Is the explanatory memorandum entirely inconsistent with Sir James's point that the maintenance regulation itself covers intra-state disputes?
My Lord, I think it is, but I don't think you even need to get to the explanatory memorandum to do that. One simply has the wordings of Articles 12 and 13 of the maintenance regulation itself.
Very well.
External aids can help in what I say were genuine cases of ambiguity. Those words mean what they say. The other matter I'll deal next, if I may, with context and the provisions, as it were, as they stood. We've dealt with that to some extent at the outset of our written case. If I can just quickly take the court, please, to paragraphs 19B and C, the two aspects I want to emphasise there. That's MS 2106 and 2107. Parliament enacted a clear, comprehensive regime to discourage, prevent as far as possible the ugly word bifurcation within the United Kingdom, the idea that one part of the United Kingdom would deal with divorce and the other part, another part could deal with financial matters arising out of divorce. And that's the points that we make in relation to paragraph 11 of Schedule 1 to the Domicile and Matrimonial Proceedings Act 1973. And of course, Parliament enacted matching parallel systems for both England and Wales and Scotland when it did so. And of course, there is no ability to say that if you've been divorced in one part of the United Kingdom and potentially had the ability to apply for financial relief there, you can then under Part 3 of the 84 Act seek further provision in another part of the United Kingdom. It's simply not available by the definition of an overseas country in both Part 3, which applies to England and Wales, and Part 4, which applies in Scotland. And just briefly, if I may, in relation to the 1973 Act, can I take the court, please, to tab 48, which is in volume 4 of the Secondary Authorities. No, it's not, I beg your pardon, wrong tab. Tab 63, sorry. That's in volume 5 at MS 1678. And that's the Law Commission report that gave rise to the 1973 Act, the Domicile Matrimonial Proceedings Act. In particular there at MS 1689, having dealt with the rules about staying matrimonial proceedings, there's a heading Ancillary Orders. And so, of course, I accept that this section is dealing with what might be called ancillary relief. But one can see on the next page, at paragraph 97, the purpose of those provisions is in order to ensure, as far as possible, that everything is dealt with in the country where proceedings are continuing. And it's absolutely right to say that on their face, the provisions of paragraph 11 of Schedule 1 don't apply. They don't catch an application under Section 27. But one can see what those provisions were trying to do. So if I can move on to the argument about internal aids, as it were, that's at paragraph 41 of our written case at MS 2119.
Sorry, what's that MS number again, please?
2119, sorry, my lord.
Thank you.
We have the presence of Articles 12 and 13 for the first time in the domestic legislation. That is a clue as to the intention of Parliament. Whether that means that they were intended to exclude forum non-convenience is, of course, the question. If the intention is to provide a simple, quick, efficient, certain method of jurisdiction, then we do say it is odd and unhappy that there's no definition of when a court is seized for such a scheme. And in that context, it might be said that having a forum non-convenience power available to either the court first seized or second seized could cut through what would otherwise be a sterile debate as to which of the courts in England and Wales or Scotland were first seized, because, of course, there's no definition at all, and the assumption is we're left with national law in relation to that. So, in terms of Articles 12 and 13, our submissions are these. They expressly govern the court's behaviour, or the behaviour of courts other than those first seized. It is only a matter of European jurisprudence that say outside those circumstances no stay is permitted. And we know that that European case law doesn't apply to internal forum disputes within the UK, and that's the case of Cook and Virgin Media.
Why bother to have Articles 12 and 13 at all if you've got forum non-convenience principles available?
Lady, I accept that it might at first sight seem a puzzle, but if you have a power to stay on forum non-convenience grounds, then you have a power that's available to a court that's first seized.
Yes, but why bother to have these at all? One of them only gives a discretion anyway. The other one bites into any forum non-convenience power that might be retained because the court is directed that it shall stay. Why bother to regulate some of it?
My lady, I'd say in relation to that, that the court second seized must stay under Article 12. And of course, the court first seized under a forum non-convenience may say, well, we were first seized, but for a number of reasons, in fact, the court second seized is the more appropriate forum. And in the context of the United Kingdom, where there may be, for instance, divorce proceedings in the part of the UK where the court second seized is, that might be the appropriate response of the court. The argument, I think, that effectively, or the point you're putting to me, is that the very inclusion of those articles itself means that forum non-convenience is gone. And I say that...
No, I'm asking. I'm not telling,
well,
I'm asking.
My lady, we come to this point, I think, from a situation of confusion. We've already seen the explanatory note. We've seen no reference in the explanatory note to the existence of forum non-convenience as a power to resolve maintenance dispute under the existing law. We've seen no reference to that's actually been a bad thing, we must get rid of it. There's just no, as I say, it's gone, if it has gone by the mere inclusion of Articles 12 and 13 in the domestic scheme, it's gone silently. So I accept that they are strange bedfellows, but they can rub along, it's my submission. And indeed, the test is whether the retention of the common law power is inconsistent with the new provisions that have been inserted, and I say they're not.
But part of it's gone, hasn't it? Because of the mandatory direction to the court first seized, it shall stay.
Well, my lady, I say it hasn't, in the sense that that only bites on a court second seized. It doesn't prevent a court first seized from saying, thank you very much, court second seized, for staying your case whilst we work out what we're going to do. But we've decided now that the right thing to do, in fact, is to send it back to the court second seized because that's the more appropriate forum. That, in the context of internal United Kingdom family law, is on a par with the power to do the same in child disputes and divorce disputes.
On this argument, the court which is first seized can then decline jurisdiction.
My lady, yes.
Despite paragraph 12.2. I know that's a mandatory one, but you could end up. So if that's happening, is the jurisdiction of the first court not established? Because a jurisdiction being established isn't the same as not declined. I mean, it either is established or it isn't. It's a fact, isn't it?
Certainly in the wording as it would be understood at European level, where there's no possibility of a court seized declining jurisdiction on forum non-convenience, yes, but at the domestic level, I'd say that the court might not have established jurisdiction if it decides not to exercise it.
Well, you have to say that, because otherwise you could end up with no court having jurisdiction on this argument. Because all courts, other than the first court, are obliged to decline jurisdiction under 12.2. And if established means the usual European meaning of established, then you haven't got a court at all if the first court refuses as well.
there may come a point, lady, and where if the first court declines jurisdiction, there's no longer, as it were, a pending claim, and it's simply open to someone to bring a fresh application in the court, which would otherwise be second seized. So I think there are ways around that as well, my lady.
Yeah. Okay, thank you.
In terms of Articles 12 and 13, as I say, they govern the conduct of courts other than those first seized. The rule at European level is not express. It's a matter of the jurisprudence of the Court of Justice that outside those circumstances no stay is permitted. That comes from a different regulation and a different convention, whereas under the judgments regulation, one has a default rule of suing a defendant where he or she is domiciled, and the need for certainty. The maintenance regulation is a different regulation in any event. The choices of jurisdictions are wider, the language is permissive, and of course the whole structure is non-hierarchical, unlike that under the judgments regulation.
At some point, we've got to take a microscope to Article 13, but presumably the microscope comes in your final section. Very well.
And whereas repeatedly it has been emphasised under the judgments regulation that certainty is the key, and defendants need to know where they're going to be sued, and plaintiffs or claimants need to be able to predict where they can sue. In the context of the maintenance regulation, the only reference that I can see to certainty is in recital 19. If I can ask the court to go there, that is in the primary authorities volume tab 5, MS 104. And the reference to legal certainty there is in enabling parties to have a choice of court. And that's the only circumstances that certainty comes in there. So we have different circumstances, different intentions behind the making of the regulation at the European level. The final point before I move on to what the test is for the implicit removal is to say that as was observed in the case of Mittal, the matrimonial context is that there is just one pot to be divided, and so, if at all possible, multiple proceedings in different jurisdictions should be avoided where possible. And that is something said in the case of Mittal at paragraph 35. That's volume 4. 43, thank you very much, and that is at MS 1181. So if I move on to the test, I say that the relevant authority is that of the Child Poverty Action Group against the Secretary of State for Work and Pensions. That is authority 11 in the primary volume at MS 320. The issue in that case was whether a claim in restitution for recovery of wrongly paid welfare benefits could be brought in circumstances where Section 71 of the Social Security Administration Act 1992 provided for a scheme for the recovery of such benefits, and it did so only where misrepresentation or non-disclosure had been established, and the decision of the Supreme Court was Section 71 had been intended to be a complete code, and therefore the new statutory scheme had impliedly removed any common law remedy that the Secretary of State had previously had.
Sorry, could you give me that? That's the CPAG case, isn't it?
Indeed, my lady, yes.
Could you just give me the page reference again, because I've
MS
obviously written it down
320.
wrong.
MS 320.
320.
Sorry, yes.
Thank you very much. No. Yes.
And paragraph 28, there are about 3 or 4 passages I wanted to take the court to MS 335. The opposite letter E, there's a quote from an earlier authority in the tax case. The statute must positively be shown to be inconsistent with the continuation of the ordinary common law remedy otherwise available. Another way of putting it was at paragraph 31, opposite letter F, the next page. The question is whether, as a matter of statutory interpretation, the relevant statutory provision is intended to be an exclusive code. Excuse me. And I also draw the court's attention to the final sentence of that paragraph, the presumption, as it were, or my understanding of the end, that last sentence, is that suggestion that you apply any presumption or anything like that is not right. And the questions that were put at the end of that paragraph were not the relevant questions. But,
Sorry, I'm afraid I don't follow that.
at the end of paragraph 31, my Lord, I'm doing my best to deal with the double negatives at the end of that paragraph. It's a suggestion there that one of the tests could be, as a matter of logic, could the common law remedy coexist with the statutory scheme for discovery? And I read that sentence as saying that is, you don't answer the question in that way.
I'm not sure about that, Mr. Horton. Rather, the question is, anyway,
it's a point that
for ourselves.
I think there are several negatives that need to be probably
He sums the
disentangled.
matter up, doesn't he? The last sentence of paragraph 34, Mr. Horton. The question is whether looked at as a whole, a common law remedy would be incompatible with the statutory scheme. Yes?
My Lord, yes, and you'll also see, albeit a comment rather than a test, in paragraph 35, a reference to the speech of Lord Millett in the Unisys case. The Unisys case was, should the common law of dismissal be developed alongside the statutory framework for unfair dismissal by having industrial tribunals or employment tribunals dealing with those and the common law courts dealing with dismissal as well. And Lord Millett said that would be a recipe for chaos. Now, of course, that's not the test, but it's an indication of the sort of inconsistency, perhaps, that we are looking for. So I come to the question, is the retention of a power in a domestic court to stay proceedings for maintenance on the grounds of formal non-convenience in favour of another part of the United Kingdom incompatible with the inclusion of those Articles 12 and 13 into the internal scheme? And it's my submission it's not. Fixed rules, such as the ones in Article 12, are perfectly capable of standing alongside discretionary rules. And the exchange I had with my Lady Black a moment ago about the ability of the court first seized to stay on formal non-convenient grounds indicates that. Of course, there are other examples that we give at paragraph 51 of our written case at MS 2125. And of course, a directly analogous situation is the scheme for allocation of jurisdiction within the British Isles in relation to divorce under Schedules 1 and 3 of the Domicile and Matrimonial Proceedings Act 1973. You have the mandatory stay under paragraph 8 alongside what is now understood to be a forum non-conveniens power in paragraph 9. And the other examples there are set out on page 2125. Of course, it is not just that Articles 12 and 13 only govern the behaviour of courts other than those first seized. Articles 12 and 13 assume that there are two courts that are seized. And of course, forum non-conveniens is available where not yet in the other jurisdiction has there been a relevant claim. So I say that strange bedfellows or not, they are not neither inconsistent with, nor do they cover precisely the same ground, to use the words of Lord Dyson at paragraph 33 in the Child Poverty Action Group case. And I say, rather than a recipe for chaos, it is a recipe for sanity and following the clear steer made by the provisions of Schedules 1 and 3 of the 1973 Domicile and Matrimonial Proceedings Act. Answering a different but related question, are the 2011 regulations intended to be an exclusive code? Slightly different way of asking the same question. Again, I say no. Of course, Schedule 4, as amended when the judgment regulation came in, was not an exclusive code. It told us which courts had jurisdiction, and we had to look outside the 1982 Act to find forum non-conveniens, albeit that it was expressly preserved by Section 49. Likewise, the 2011 regulations have to rely on other provisions to make them work within the United Kingdom, or for a scheme of recognition and enforcement within the United Kingdom. We've always had the ability to have a maintenance order made in one part of the United Kingdom, registered and enforced in another part of the United Kingdom. That's the Maintenance Orders Act 1950. And that legislation continues in force. It's been amended slightly by the 2011 regulations. But, as I say, the exclusivity relies, I say, the answer is no. One, because, as I say, we have that provision. Wisely or otherwise, the makers of the regulations disapplied the provision about when a court is seized. So we have to go outside the scope of the 2011 regulations to answer that question as well. So, looked at it on that basis, I also say the regulations are not an exclusive code. So that's my primary submission, that forum non-conveniens, a power to stay, is available in all cases. My alternative submission, which picks up on the written case of the Secretary of State, is this. If the actions are unrelated, then neither Articles 12 or 13 govern the situation. Either court, or just the one court, has the power to stay on grounds of forum non-conveniens. But if the actions are related, it might be said that there, the power to stay is confined by Article 13. Only the second court seized may only stay if Article 13, the conditions are there, are met, but that still leaves the court first seized to be able to use forum non-convenience grounds to stay in favour of the other court. And I say that my primary submission is there is no overlap. My alternative submission is the only potential overlap where matters are covering the same ground is where a court would have power under Article 13 to stay on discretionary grounds. It might be said there that having two coexisting powers to stay on discretionary grounds might be have not been intended. So, ladies and my lords, my submission is that when one applies that test in the context of this legislation, the test is not met for the implied removal of that power, and the Court of Appeal were wrong to say that it was so impliedly removed. Before I move off issue 2, I just want to say something very briefly about the relevance of Section 16 of the Matrimonial and Family Proceedings Act 1984. That is touched on in the judgment of the Court of Appeal at paragraph 60. That's at MS 2233. And I make it plain
So
that...
did you say 2223?
2233, my lord, sorry.
No, that's my fault.
And that's the judgment at page 60. And clearly the Court of Appeal considered that this was a relevant matter. My submission in relation to Section 16 is that Section 16 is not about forum non-convenience. And Section 16.3 does not prevent a stay on forum non-convenient grounds within the UK, which is what this case is about.
Where do we find Section 16?
Tab 4, MS 64, and the actual section itself is at MS 70.
MS?
70, sorry.
Thank you.
Bear in mind that the 2011 regulations are regulations which extend to the whole of the United Kingdom. And so, in my submission, the answer to their interpretation must be, say, a matter for the law of all parts of the United Kingdom. Section 16, although the head note, or the side note, as it were, of duty of the court to consider whether England and Wales is the appropriate venue for the application, of course, it doesn't actually say that in the section itself. It says whether the court, whether it's appropriate for an order to be made by a court in England and Wales. And the wording is different to that in section 28 of the Act in terms of Part 4. But the main point in relation to that is the decision of the House of Lords in Agbarji. That is Volume 3, Authorities 37 and MS 1070. And paragraph 49 of the judgment of Lord Collins makes it plain that Section 16 is not to do with forum non-convenience. The whole point of Section Part 3 application is that there will have been a court already involved, and whether or not England and Wales should, despite the divorce somewhere else, go on to make orders under Part 3. And of course that's inherent because of course it's expressly stated in Part 3 that the court can grant leave to apply even if a foreign order has already been made. The short submission in relation to this aspect is Section 16(3) only prevents dismissal in the context where dismissal would be inconsistent with the jurisdictional requirements of the maintenance regulation. And it's my submission that there's no jurisdictional requirement in the maintenance regulation or indeed the 2011 regulations which would prevent dismissal of an application under Section 16(1).
Have I got this right? We're by definition in the 1984 Act dealing with an extraordinary power of a court in England and Wales to order financial provision after a divorce has taken place abroad, basically. No such power exists as between England and Wales and Scotland. So what this is talking about is something completely different from what we're talking about.
Yes. The only circumstances I could possibly conceive where Section 16 comes into play is if you had a couple that got divorced, let's say, in the United Arab Emirates. One of them lived in Scotland, one of them lived in England, and there were competing applications under Part 3 and Part 4. And in my submission, it would be perfectly acceptable for both the Scottish court to decline jurisdiction under forum non-convenience grounds, and as it would be for the English court to do so.
Yes, that situation could arise. I see that. Yes.
But the amendment that led to the new 16(3) of the 1984 Act, that is clearly prompted by the usual interstate rather than intrastate covering of the maintenance regulation and indeed Schedule 6.
I entirely agree.
Yes.
What if the court in England and Wales, by saying it's not appropriate, is going contrary to what would be the normal jurisdiction absent foreign non-convenience under the 2011 regulation?
I'm just trying to see a circumstance in which that might arise, milady.
It's thinking it isn't appropriate to give financial relief here, and getting towards declining to do so, but if it does so, it takes away the court which would otherwise have jurisdiction under the maintenance regulation.
Lady, I think the answer to that question is in the equivalent Scottish provisions. If I can just take the court to those, they're in the 84 Act, and that's Authorities tab 4 and section 28 at MS 93. The Scottish approach to, in Part 4, as compared to the English approach, the approach in England and Wales under Part 3 is very different. There's no duty to consider whether the court's appropriate, but it sets out, as it says there, the circumstances in which a Scottish court may entertain application. There are conditions in subsection 2 which are called jurisdictional requirements, and historically they've been related to domicile and habitual residence. And then in section 3, there are what might be called other threshold conditions for making of an order under Part 4. One of those, on the top of MS 94, is the marriage having a substantial connection with Scotland. And what the 2011 regulations did was twofold. One can see that in the italicised words for subsections 3A. They do two things. They disapply, if the maintenance regulation applies, then it's those jurisdictional requirements that operate instead of subsection 2. And then as far as the subsection 3 threshold criteria are concerned, they remove the subparagraph E, which deals with substantial connection with Scotland. So what I say, and it's again also, I say it's it's supported by the decision of Mr. Justice Cohen in a case called Patanen, which I'll come to in a moment, and that is that the purpose of Section 16.3 is to prevent a court declining jurisdiction on the absence of connection with England and Wales. That's the most, the highest it could go. There may be other circumstances which it would be inappropriate for a court in England and Wales to make any order. For instance, where there's an existing order that's entitled to recognition. That's not a jurisdictional rule. That's a rule that goes to the fact that an order has been made in a maintenance regulation state. It's entitled to recognition without more. And the English court, or another second court, is not entitled to review its substance, which is what we'd be doing if we went on to make a further order. So there are all sorts of reasons, I say, why Section 16.3 is not about forum non-convenience. It's difficult to establish its ambit entirely precisely. If I can just deal with the Patanen case very quickly, that is tab 53. It's in back of volume 4 of the Secondary Authorities, MS 1548. That was a case very recently reported, decision of Mr. Justice Cohen, a Part 3 claim following a Russian divorce where the applicant claimed that she had not received a fair award there. She had pursued litigation in Russia, Cyprus and the United States following the initial divorce settlement, as it were, in Russia, as the judge commented at MS 1565, at paragraph 70, England and Wales is only the fourth jurisdiction that she had resorted to. And in circumstances where the connection with England and Wales was described as recent and modest, the court declined to entertain the application. The particular passage I'm relying on is at paragraph 71 onwards at MS 1565. And the argument put forward on behalf of the applicant was that at paragraph 73, that effectively remove entirely section 16.1 and 2, where jurisdiction is founded on the maintenance regulation, where someone says, I am a maintenance creditor and I live here. That argument was rejected at paragraph 79. And the court will see the conclusion the judge reached there, and I say that's consistent with how the scheme works in Scotland as well. So my main submission in relation to section 16 of the 84 Act is it simply is irrelevant and it can't provide, as a statute in one part of the United Kingdom, the answer to regulations which apply throughout the United Kingdom. So, my lords, the main thrust of our argument has been on the construction of the 2011 regulations. The subsidiary argument that we make is at paragraph 55 of our written case at MS 2127. It is what I call the structural argument. Beforehand, under the scheme where maintenance was expressly within Schedule 4, you have a scheme where claims or types of claims could be taken in and out of Schedule 4 by statutory instrument, and there was a specific provision that directed courts as to how it should be interpreted. If it is right that Schedule 6, as it were, is cast adrift from that structure, we have no provision which tells us how to interpret it, whether it should be having regard to European jurisprudence or follow them strictly. And indeed, we have the situation where types of maintenance claim cannot be taken in or out of this new scheme by statutory instrument. The 2011 regulations have, so far as I'm aware, been amended twice, once on the coming into force of the Hague Convention on the International Recovery of Child Maintenance 2007, and then secondly when the Family Court came in. On each of those occasions there was specific statutory authority to amend them.
I think the 2011 regulations provide for a report in or before 2016. Have we got that?
My Lord, I can't say categorically that it doesn't exist,
No.
but I put quite a lot of money on it.
We haven't got it yet?
No.
Ah, well, we'll get it.
It's one of
tomorrow.
those provisions where the Secretary of State says it shall be done, and
Well, we must ask Sir James tomorrow.
the structural argument, as I say, is set out there. The key point that I make is the wording of section 16.4, that it is surprising that the words, or any reference at all to Schedule 6 to the maintenance, Schedule 6 to the 2011 regulations is there at all if they're not to be linked in some way. But I say, ladies and my lords, this is very much a secondary argument. My main submission is in relation to the construction of the regulations themselves. Before I finish, therefore, on issue 2, I just want to say a few more things. We set out at paragraph 54 that not only is the retention of forum non-conveniens consistent with the overall scheme for private law family disputes within the United Kingdom, but it will enable injustices to be avoided. The example I give in paragraph 54 is where Party A has pre-acquired capital but no income. Party B is capital poor but with a high income. If that Party B, is in England and Wales with children, and Party A with the pre-acquired capital in Scotland, if there is a divorce in England and Wales, but a claim for aliment in Scotland, then if the power has gone, then for a start, there is no needs-based claims available in England and Wales because maintenance in Scotland is first in time. Of course, that would leave the rest of B's claim for ancillary relief in England and Wales, but that would only be a sharing claim, and if all the assets are pre-acquired, that would not be worth very much indeed. And regardless of the fact that it would be suboptimal at best to have two different courts dealing with maintenance and the consequences of relationship breakdown in different parts of the United Kingdom, there will be circumstances where injustices will arise.
So why would there be two different courts dealing with it?
My Lord, I say it doesn't make any sense to have two different courts dealing with it, but you'll get that situation in cases where an English Section 27 application is made.
But a forum non-convenience is not available to you. I mean, how would the Scottish court come to be dealing with it?
Well, the Scottish court could deal with, as it were, the non-maintenance aspects, the sharing of matrimonial wealth. And that's exactly the same as in the example I give. If the Scottish court is fixed with an aliment claim, which is a claim for maintenance within marriage, which, unlike Section 27, ends on the divorce, then the maintenance issue is now reserved, as it were, north of the border. What's left in England and Wales on ancillary relief is simply the sharing claim. And of course, that may not be worth very much depending on the source of the assets in question. So I say it makes no sense as a matter of practical policy to have that split between two different parts of the United Kingdom. The legislative history says that we didn't intend to do that, and as I say, I say it's simply not very attractive to say, well, that's how it works, that's the way it is, we'll just have to deal with it.
Does Scotland have an equivalent of Section 27?
My lady, yes. So this is referred to in the judgment of the Court of Appeal. I think it's at paragraph 13.
Thank you.
13 is a summary of how it works in Scotland.
Yeah. MS 2221.
But this is the one that ends on divorce?
Yes, sorry. There was some material that we put before the Court of Appeal. The ability for a spouse to claim aliment, as it were, outside the provisions of the the Family Law Scotland Act 1995, certainly it didn't appear to be disputed before the Court of Appeal that that was a provision that allowed maintenance to be made independently of a writ for divorce. But unlike in England and Wales, where the duration of Section 27 orders can extend beyond the ending of the marriage, north of the border, an order for aliment ends on the coming into effect of the decree of divorce.
Because you wouldn't get a situation of that could enable you to have two different courts dealing with money, but you wouldn't get a situation of two different courts dealing with money associated with divorce, would you? Because one would have to be stayed as it was ultimately dismissed in this case.
Well, I suppose it depends on how closely you define the cause of action of maintenance. It's something we touch upon in relation to, on the related actions point. Is maintenance within marriage, for as long as the marriage lasts, a different cause of action to maintenance that, as it were, is made in favour of a former spouse?
No, I'm just thinking about, can you have two sets of divorce proceedings running within the United Kingdom in different parts of the United Kingdom? You can't, can you? So any relief that is ancillary to divorce can only happen in one part of the UK.
Yes, subject to the very limited exceptions in paragraph 11 of the 1973 domicile.
So the only situation in which you can get money being debated in two parts of the United Kingdom is where you have either two freestanding financial relief claims or one divorce and one financial relief.
Yes, one divorce and one non-ancillary financial application. Yes.
Yeah, right. Thank you.
And the lack of, as it were, of balance in the scheme is that England and Wales says that it can make orders within marriage that would last beyond the dissolution of the marriage, unlike the position in Scotland.
Was there an argument about that was shelved in the Court of Appeal?
Yes.
Was it your argument that
was
it
my
couldn't?
argument? I was invited, or it was suggested that perhaps, given that it was an interim order and the duration of the final order might not be a matter to be debated at that point, and I didn't pursue the point. It is also true to say that we sought permission again on that, and permission in this court was not granted. But there we are. Forgive me, if I can just say a few more things on issue 2 before moving on to issue 3. Yes, so the those circumstances, the overall context, the lack of bifurcation within the United Kingdom, we say, are all part of the court's task in construing the 2011 regulations and divining the intention of the lawmaker. Ladies, my lords, I'll move on to issue 3, which is in relation to the vires of the making of the 2011 regulations, insofar as they are construed to remove the power to remove forum non-convenience from intra-UK maintenance disputes. The premise of our argument, and I've already dealt with this, is that forum non-convenience, for intra-UK cases is not incompatible with the European maintenance regulation. As we've said already, the European legal order is unconcerned with internal allocation of jurisdiction within member states. The wording of Articles 12 and 13 assume there will be proceedings in 2 different member states. And therefore, if that submission is right, then any removal of forum non-convenience from the internal scheme wasn't done at the European level, didn't occur, therefore, by virtue of Section 2.1 of the 1972 Act, and therefore would have come into effect only by virtue of the regulations themselves under Section 2.2b of the 1972 Act. So that's our starting premise. Our case is that there are a number of matters we say are unobjectionable. If one can look at paragraph 64, subparagraph B, MS 2132, what we as a member state needed to do in order to make the maintenance regulation work and have effect was to designate central authorities to tell other countries where incoming orders should be sent to, which provisions of domestic law are going to be used in order to make sure that an order made outside the United Kingdom can be enforced as if it were an order made here. And those are the provisions made in Schedule 1 to 3 of the 2011 regulations. If one just turns them up very briefly, it's a primary authorities bundle at Authority tab 6, and one can see at MS 185, we need to have a central authority. The maintenance regulation allows countries with more than one system of law reference to a territorial unit to designate different central authorities for those territorial units, and so we comply with our obligations there. Secondly, paragraph 64C, we say that it's unobjectionable to align the primary rules of internal jurisdiction with those of the maintenance regulation by incorporating, indeed, Articles 3 to 8 of the maintenance regulation into the internal scheme. It wasn't necessary for us to do that.
I wonder whether on this varies point you're able to put half a cake in front of us. If there is varies to have gone on and dealt with intra-UK, it's quite difficult for you to say that one aspect of it, namely the presumed removal of forum non-conveniens, was ultra-varies. Haven't you really got to go the whole hog and say that Schedule 6 is outside Regulation 2, is outside Section 2.2?
My Lord, I say no for this reason. the whole original scheme of Schedule 4 was that we copied the bits of the Brussels Convention that we liked for internal jurisdiction disputes on civil matters in the UK. We expressly made a choice there in enacting the 1982 Act in saying that where more than one part of the United Kingdom had jurisdiction, the way to resolve that was under forum non-convenience. Parliament made that choice. Where the primary rules of jurisdiction are amended at European level, when we have the judgment regulation, we can amend, as indeed Schedule 4, there was always the power to amend Schedule 4 to bring things in and out at any event. So what we have there is a continuation of a scheme modelled on with the bits that we like from the European legislation in our internal scheme, still with forum non-convenience. The analogy that I want to use, as it were, is that in the case of Pothegary about the small further step on the path well trodden. Because my submission here is actually, it's not a small further step, it's a very large step. It's a large step that reverses a policy decision which is in an Act of Parliament. It's one thing to mirror the approach in the 82 Act and to make further decisions as to which of the provisions of primary jurisdiction at EU level we're going to apply internally. That's what the 1982 Act did. That's what, effectively, when the Brussels I regulation comes in, the order that amended the 82 Act did a similar thing. The reference to the small further step is in the case on the reversal of burden of proof in victimisation cases. That's the case of Pothecary, Withenweld and Bullimore. Well, that's in volume 3 of the Secondary Authorities, tab 38 at 1078. And the phrase has been adopted in other cases, but this is where it comes from. And the facts of that case were, as I say, that there'd been a European directive requiring member states to reverse the burden of proof in sexual discrimination cases. The amending regulations under Section 22B went beyond that and applied it in victimisation cases, and although that was not required by the relevant directive, it was considered to be a small further step on that path. One can see the language used. I think it's at paragraph 42 at 1102. The court rejected the submission that this was a choice made available by the directive itself, but it was related to or arising out of the change in law at the European level. And that, say that use of that phrase has been adopted in later cases. I just want to say a few things about it, that it's always useful to have a pithy phrase like that. The danger is that one generalises from that into a rule in later cases. My overall submission is one needs to be clear, if one using an analogy like that, is what is the path, where's it going, and indeed how big the step is that one's taking along it. And in the context of that case, where the burden of proof directive had expressly said that member states were not prevented from introducing rules of evidence which were more favourable to claimants, I say that that was a signpost along that path to say it is permissible to go further that way. my submission in relation to this case is that what does the maintenance regulation do? It doesn't remove, at international level, forum non-convenience. Forum non-convenience had gone. It had been gone since the mid-80s, when the 82 Act had come into force. So if one is saying that this is, by saying removing forum non-convenience is a small further step along that path, that is not something one gets from the maintenance regulation. That's already happened at international level 20 years or so before, my lord. And indeed, forum non-convenience had peacefully coexisted internally with European instruments which had forbidden it at the international level. So what the maintenance regulation is doing is tidying up, improving matters at international level. It's removing national law when it comes to third state disputes and generally, I say, making matters slightly more maintenance creditor friendly. The path trodden by the maintenance regulation, in my submission, was not removing, as I say, forum non-convenience between member states. That path was Articles 3 to 8 of the maintenance regulation. To give my lord an example, Article 8, as it were, forbids the of modification of a decision in one member state if it would be made in the first member state where the maintenance creditor resided and continued to reside, in broad terms. And we decided to adopt that as part of our internal law. We amended the Maintenance Orders Act 1950 to say if there's an order made in England registered in Scotland, that Scottish court can no longer vary the rate of payments once it's been registered in the Scottish court. Now, there was no need for us to do that. Article 8 on its face applies only to situations which apply between member states. You can see that. MS 109 in Authorities tab 4. So where you have a scheme that already has internal rules of jurisdiction based on European law, but with forum non-convenience, where you have a change at the European level and we decide to incorporate some of those new rules of jurisdiction, the small further step is to apply those internally. But removing forum non-convenience had been done on an international level many, many years before, and we, Parliament, had made it the law of this land, say we're not going to do that. By making the 2011 regulations in the way as it is said that they operate, the regulations effectively reverse a policy decision made by Parliament. And it's in that context, when one considers the comments of Lord Manson Nolan about what Parliament is intending to do by allowing regulations to be made under Section 2, that I say it's important. In our written case, we refer to Lord Manson's judgment at paragraph 61, and in particular, the very last line on that page of MS 2131. The context upon which derogation, as it were, of legislative activity is, or devolution of legislative activity is made to the executive. And indeed, paragraph 66 of the decision in USA and Nolan, which is at MS 386, and that is tab 13 in the primary volume. This is a extension of an EU regime domestically into an area specifically excluded, and in a way not just specifically excluded from the European law, but in a way which runs contrary to an earlier Act of Parliament. And so I say that's the real difference between cases like USA and Nolan in this case. You have in that case a situation where Parliament goes wider than required initially, deciding to extend a directive to other situations not required by the directive. Well, you could say that's the same is true of the 82 Act. But of course, one key difference in this case is that the direction of travel is against what Parliament had decided in the 82 Act to retain forum non-convenience. So I say, my Lord, I can have my half a cake, as it were. It's actually, my submission is that the only declaration I seek is that to the extent that, and of course it's a matter for this court's decision as to what extent, if any, that is the case, that to the extent that Schedule 6 purported to prevent a court in England and Wales, or in the United Kingdom, from staying claims within the scope of the regulations on the grounds of forum non-convenience, that Schedule 6, or the particular provisions that operate to do that, are ultra vires. There are some other points. Just to give the court the references to what I was saying in relation to Maintenance Orders Act 1950. The amendment to that is at MS 196-7. That's in Schedule 7 to the 2011 regulations. As I say, that's why the application of the EU rules of primary jurisdiction within the UK are, in the jargon, gold plating. Ladies and Lords, I'm happy to move on to issue 4.
Well, how long do you expect to take on issue 4?
About 30 minutes.
It would suit you if we adjourn now, wouldn't it, Mr. Horton?
Actually, no, I'm realise it was quite so early. I'm going to carry on, if I may, if that's convenient.
It's 5-2, so you've got 5 minutes.
Yes. I'll make a start, my lady. Thank you. Lady, in relation to issue 4, again, our argument has two strands. Firstly, that this maintenance claim and this divorce writ can be related, even if one applies, as it were, a strict European law approach. But our secondary submission is that this is domestic law, and one needn't have such a rigorous approach. There are no international law consequences of taking a less restrictive view of the ambit of Article 13 of the 2011 regulations. So in terms of the first matter, I've set out the terms of Article 13 at page 2134. and two general observations are made there. Firstly, that the concept of irreconcilable judgments is one that appears not just in Article 13, but also in other articles. And it's right to say that its scope is generally considered to be wider in Article 13 than in the other articles. But our primary submission is that whereas the Court of Appeal considered that the authority of more and more was a complete answer to the point in question, we say the authority of more and more didn't ask the right question. And the question is the extent of what is now Article 13, what was then Article 28. Before I come to more and more, just to say on page 2137, paragraph 75, if both claims have to have as their cause of action maintenance that would be related, which is the decision of the Court of Appeal in Moore and the decision of the Court of Appeal below, then it, in my submission, leaves very limited scope for the operation of Article 13. And in domestic law circumstances, let's suppose one has an application to enforce a charging order over a spouse's interest in a matrimonial home at the same time as an application by the other spouse for a transfer of that interest to them. The causes of action on which those two proceedings are obviously different. They are clearly related, and they are clearly situations where if they both are heard separately, there is a risk of irreconcilable judgments. That's a domestic example. One can see all sorts of other examples where there are debt claims brought against spouses and satisfying one party's claim for ancillary relief would be inconsistent with the satisfaction of a debt claim. So, in general, I say, as a matter of first principles, the law should not be that they should have to have the same cause of action. Prior to June 2011, of course, maintenance claims were within the scope of the judgments regulation. And had there been, for instance, a debt claim in one jurisdiction and a maintenance claim in another jurisdiction, it would be, in my submission, perfectly possible for, of course, they wouldn't be the same cause of action, but Article 28 of the regulation could easily be applied in those circumstances. In my submission, the hiving off of maintenance into its own regulation would not have been expected to limit the court's powers in that regard. My ladies, my lords, at that point, I wondered if I could stop and deal with more in detail after.
Yes, thank you. We'll adjourn now and resume at 2 o'clock.